You're listening to Crashes, Claims, and Clarity, hosted by Darrell Burrow, a Georgia-based personal injury attorney with over 30 years of experience and founder of Burrow and Associates. With a background in both legal strategy and compassionate client care, Darrell has helped over 10,000 individuals and families navigate life after injury. Guided by his Christian faith and a deep sense of justice, he brings expert insight, personal stories, and powerful interviews to every episode. If you're looking for truth, support, and clarity in the aftermath of an accident, this is your place. This is Crashes, Claims, and Clarity.
Well, hello everyone, and welcome to another episode of Crashes, Claims, and Clarity. I'm your host, Darrell Burrow, founding partner of Burrow and Associates, a law firm with our headquarters in Gwinnett County, Georgia, but serving the entire state. Today, we have the pleasure of being joined by Mr. Mike Bascom. He is the founder and senior attorney of Bascom Law. He helps families, business owners, retirees, and veterans protect their assets and prepare for some of life's unexpected turns. Mike focuses on estate planning, elder law, probate avoidance, trust, incapacity planning, and business succession. He is also an author, educator, and creator of the Asset Retitling Workshop and the Succession Team Training Workshop. Well, Mike, thank you so much for joining me today. I appreciate it.
Hey, glad to be here, Darrell. Thanks for inviting me.
Sure. Well, we'll launch right into these questions to try to educate not only myself, but also the audience. Your approach emphasizes preventing problems instead of simply preparing documents. What warning signs tell you a family's estate plan may look complete, but fails during a real crisis?
Well, the starting point is going to be looking at the documents. And there's three things. Number one, make sure that there actually is a written plan. Number two, make sure that the plan is current. And number three, make sure that it's applicable to this state. So let me talk about each one of those briefly. Sometimes people will come to us not knowing that the state of Georgia has written an estate plan for them if they don't have a plan. Sometimes they'll say, oh, my family knows what to do in case something happens to me. Well, that's going to be your sure recipe for disaster unless you're satisfied with the plan that the state of Georgia has prepared for you. Now, the state legislature, I don't think they have any ill will, but they have to write a generic plan that's so broad that it covers everyone, which in my interpretation means it probably covers no one. It's going to be too broad for them. So make sure you've got a written plan in place. Number two, frequently we have people who move in from out of state and they have not updated their plan. Each state has their own rules. And so whatever state you live in, that's the state that's going to govern those particular rules. So for instance, in Georgia, we let witnesses on a will and a person signing a will be 14 years of age. So you'll see on the back of many wills, it'll say the witnesses and the person signing were 14 years of age or older. Well, I'm also licensed in Florida. And if you happen to move to Florida and you die in Florida, they don't allow 14-year-old witnesses in Florida. So what would happen is those witnesses would have to be located and they'd have to prove that they were more than 14, whatever Florida's rules were at the time the will was signed. So it's critical to know which each state's rules are. Frequently, we'll also see estate plans that are outdated. So if it's more than a few years old, typically 3 years old, it's worth having it looked at again. So that's kind of the third prong there. If someone's looking to save money, it's usually best if they go back to the same attorney that helped them create their estate plan to begin with. Now, if that attorney's retired or no longer in business, or your estate has grown so that they no longer can accommodate you, you may want to seek someone else out. But typically, it's most economical to go back to the same attorney that did your underlying estate planning documents. So our rule of thumb is 3 years is great. If it's been more than 5 years, you definitely need to have it looked at.
You created the Asset Retitling Workshop. How can the way a home, a business, or investment account titled completely undermine an otherwise well-written estate plan?
Yeah, we see this frequently. People will come to us with an estate plan that's in place. And for instance, it may distribute assets to their children when they pass away. And then we start to look at how the assets are owned. And the life insurance may have left their former spouse on that policy. So now when a
Mm,
person passes away, the life insurance proceeds are going to go to the former spouse, not current spouse, and not the kids, even if the will says, hey, this is how the money's to be split. So looking at how the assets are owned is going to be very critical. Oftentimes, when a married couple, when the first person passes away, 75 to 90% of the assets typically pass automatically, generally to the other spouse, not because of the will says it or the trust says it, but because that's the way the assets are owned. There's a beneficiary designation or a joint ownership. In Georgia, with regard to real estate, you're allowed to own property in two persons' names as either joint tenants with right of survivorship. And if it doesn't have that phrase, then it means it's tenants in common. Under the tenants in common, each person would own 50%. But if it has that additional phrase as joint tenants with right of survivorship, when one person dies, the other person has 100% of the asset. The time this is significant is if this is a second marriage. Then it really matters who dies first because the person who dies second, they own 100% of the property. It's not 50-50, half going to each of your families. So it's real critical that how the assets are owned, how the beneficiary designations are set, needs to be coordinated with your estate plan. Unfortunately, this is probably the single biggest area of mistake that I see that's out there.
mm. And it sounds like big life events are certainly a time that those need to be reviewed, no matter how many years it's been.
Yeah, I like that. Every time there's a significant event, it's a good time to do it. And not only for yourself, but oftentimes for the people that assist you, right? So maybe you've chosen your daughter to step in and handle medical or financial decisions for you if something happens to you. Well, what if suddenly daughter's health situation has changed, or her spouse's, or her employment situation, or she's decided to move? It's a good thing to review these on a regular basis.
Great advice. After someone receives a significant injury settlement, which assets or accounts should be reviewed before that money is invested, transferred, or used in any way?
Well, first thing I suggest is just take a deep breath and slow down. This is kind of like lottery money. And so sometimes people feel that as quick as it came, they need to spend it just as quick. And you're going to have lots of people who are eager to help you spend the money. So, number one, sit down, take some time, talk with your financial advisor, come up with a plan. I think that's going to be the critical part. When large sums are exchanged because of an injury, we have to look and see who is injured. If the person who's receiving the money was injured, there may be structures that need to be put in place to make sure the person is protected so that they don't get too much money and that they can't mismanage it, right? If that person's receiving some sort of government benefits, we also want to be cautious because we probably want to try to preserve those government benefits as much as we can. And that also applies if you're wanting to leave assets to a family member or a loved one that may be having some challenges. They may have injuries, they may have mental incapacity, etc. If that person's receiving any sort of government benefits, if you leave assets to them improperly, then you could disqualify them from receiving those government benefits, unintentionally, of course. But that's why we want to be very careful to make sure that you're not going to disqualify someone from receiving benefits that they're otherwise ordinarily entitled to.
Okay. Yeah. Small business owners often assume their spouse can automatically step in if they are seriously injured. What authority might that spouse discover they do not legally have?
Well, there's sort of two. One is power over the purse, and the other one is decision-making authority to run the business. Typically, the spouse, the first thing you want to have access to is making sure that monies are still coming to you or you have access to receive the pay that you have ordinarily been receiving. So if your spouse has been working in the business, they can no longer work there. You've been accustomed to that income that's coming in. So unless you're a signer on the account, that's typically going to stop. So this is a perfect time to talk with your insurance agent. There's different kinds of insurance products that can protect against this so that if your spouse no longer is working, no longer producing an income, that an income can be generated so that you can continue your life or make the fewest modifications possible. If you're staying home raising family, the last thing you want is to now suddenly have to throw the kids into daycare and zip off and take a job in order to try to make ends meet, if that could have been prevented.
Hmm.
Back to the other side of it, though, as far as making decisions regarding operation of the business, you may not have the ability to fire someone, so you could have suddenly a bad employee. You may not have the ability to get rid of them. You may not have the ability to shut the business down, or if the business is in the middle of a transaction, completing whatever that particular transaction is. So making sure that the correct legal authority is in place, and whether that's through the use of powers of attorneys or trusts or ownership or co-ownership on stock, all those need to be examined very carefully and thought through with your attorney when you're creating your estate plan.
Okay. Yeah, great advice. Well, Mike, the next question I have, through your succession team training workshop, you bring multiple professionals into the planning process. Who should be on that team, and where do you see communication usually break down?
Yeah, so there's sort of two teams here. One is your professional advisors, and many people will have the CPA, they have a financial advisor, insurance agent, estate planning attorney. It's important that all of those be on the same page. Now, depending on your circumstances, you may not have that team completely fleshed out. So we see people who have a small amount to people who have a really large amount of money. And, the larger net worth clients, they may even have multiples of people in those various positions. But it's important that they be speaking together, otherwise, they're going to have conflicting advice that's taking place. The other group that's important to you are the people who are actually going to carry out your plan. And I refer to these generically as your helpers. And frequently they're going to be family members or friends. Sometimes you'll go to professionals. Occasionally you'll go to institutions like banks or trust companies to handle it. But generally, these are the people that don't know what to do when something bad happens to you. And so instead of waiting until something bad happens to you and suddenly, boom, everything's dropped in their lap and now they have to scramble in order to figure out what did mom and dad want. If they can be pre-educated, then when the bad event happens, it's not going to be chaos. For myself, I have to hear things about 3 times before it really sinks in. And so the idea is if we can start that education earlier, so when everyone's healthy and happy, it's the first time they hear it. Then the second time they hear it, it's going to be more familiar. It's going to be easier to pick up. And then when the actual bad event happens, there's not going to be chaos regarding who's going to step in and handle the medical decisions for mom. The family's going to know about that. The other thing that it does is it starts to flesh out if there's going to be a problem. So from a parent's perspective, if they have invited their family to come in and we've done a succession team training workshop with them, if a particular child feels that they are not in the position that they should be in, they're going to make that clear to the parent. Now, that child may be in that particular position for a reason, and the parent may definitely want to keep them there, but it allows feelings to come out and they can start to have those conversations. It's better to have those conversations now than it is to wait until parents are gone and now you got kids who are fighting with each other. And frequently what we find is the conflict is not necessarily coming child to child, but it's child spouse and other child spouse are the ones who are
Oh,
feeding information, who are stirring the
okay.
pot. So frequently it's the in-laws who are stirring the pot as opposed to the kids. And that's stuff that can be addressed in advance, talked about, thought through, and even schemed around in order to make sure that the least amount of conflict possible takes place and minimize the influence of someone that you don't want to have input into the plan.
And that goes right back to what you were talking about earlier with a big life event that you need to revisit documents and talk with people that you have said are advisors and helpers.
Yeah,
Yeah,
I think
good stuff.
it's critical that everyone's on board and they know where everything is. That's the other thing that the succession team training workshop does is where are all the materials? Where are the documents, right? We sometimes talk about the treasure hunt. After someone passes away, there's a little bit of chaos. Where's the treasure hunt? Where's everything hidden, right? And if the parents have done things appropriately, everything's organized, right? Things are in a correct place, or there's a roadmap on where to find everything. It doesn't have to all be in the same box. But if there's a roadmap, gosh, you're going to cut down the expense, the hassle, the frustration, just the nuisance factor tremendously by getting organized and spending a little bit of time and being a little bit proactive in putting that stuff in place.
For someone who may own rental properties or several real estate investments, what happens to those properties and their income if the owner is suddenly unable to manage those properties?
Well, we sometimes see two scenarios. One is where the owner is actually serving as the property manager. In other cases, the owner will have hired someone else to serve as the property manager. That's the easier scenario. If you have a professional who's actually doing the management and dealing with the tenants, they can continue to collect rents, make sure that the plumbing's dealt with at 2 a.m. when you got the stuck pipe, those sorts of things, right? So there's a little bit of time there. The harder one is if you're the person who's actually serving as the property manager, then who's the tenant going to pay rent to? If you've passed away or you've had a stroke and you're suddenly in the hospital, if that electronic payment's not automatically coming in, someone needs to go and knock on a door and say, hey, it's time to pay. That's why it's critical that a correct estate plan be put in place so that you've got someone empowered to do that. If you don't have a plan in place, then the state of Georgia and every state has a process where someone can fill in for you. So let's take this scenario. If you're incapacitated, you've been in a car accident, you had a stroke or something, and you don't have a power of attorney, you don't have someone signed on to assist you with the business, you don't have a trust, you don't have any plan. Well, in that scenario, then it may be necessary to get a guardianship or conservatorship over you. And that's going to take probably 8 weeks. It's pretty common in the metro area to see it take that amount of time. It's not unreasonable to expect that to be $15,000 right now. It's probably a going rate. And if someone's trying to do an emergency one, it's probably going to be double that rate. That's just to be able to get someone who's authorized to go and have legal authority to talk to your tenants and collect the rents, etc. So you can see it's critical. If you've got a proper plan in place, you can make it so this can be a seamless process, but it's going to require thinking it through and making sure the documentation is put in place.
What planning or benefit opportunities do veterans and their families frequently overlook following a disabling accident or a serious illness?
Well, I'm glad you're asking about veterans. When we see them, typically they're needing to go to an assisted living facility or a nursing home. Obviously, if they've had some sort of disability, then they can file for a disability claim and increase their income if it's been related with the military time. The time that I see them is if someone needs to go to an assisted living facility or a nursing home. And many veterans and their families don't know that there are additional benefits in addition to whatever compensation the veteran is currently receiving to help pay for that care. What they typically don't understand is the cost of the assisted living facility is treated as though it's an unreimbursed medical expense. And so when you compare a veteran's unreimbursed medical expenses versus their income, if they have less income than what their expenses are, there's certain veterans benefit programs that will help boost the income to make it so that then they can afford to pay for these assisted living. Now, if we're talking about someone who's going to be in a nursing home, a skilled rehab facility, frequently it's better to chase the Medicaid programs that's there because that's going to provide more benefit. It's going to be a longer term benefit. But knowing that those benefits are available not only to the veteran, but also to the spouse of the veteran are going to be key. What's interesting about the first one that I talked about, it's a health issue that caused the veteran to go into the assisted living facility. But when you speak with the VA, it's not the health division that you go to get this additional compensation. It's on the compensation side. And that's why frequently this benefit is missed is because it's on the compensation side of VA.
Huh, okay. That's great advice. Great advice. We know that you're licensed in both Georgia and Florida. What complications can arise when someone lives in one state but owns property, spends part of the year, or receives medical care in the other state?
Yes, so each state has their own rules. Now, you specifically asked about medical care. When you have a document that describes what your medical care should be and who should be your successors, my experience is most states tend to be fairly receptive to whatever you have. So if you don't have the exact state specific form, for instance, if you have the Georgia form and you end up in Florida or vice versa, the medical care providers tend to be pretty good about accepting whatever form you have as long as it's clear who's going to be next in making decisions and what treatments you would like. The time that doesn't take place, though, is if we're talking about money matters. So oftentimes people will come to us with a financial power of attorney that says, hey, if I can't sign my name, I've got medical issue, I've got some sort of issue that allows me to not be able to handle my finances. I want so and so to step in for me. If you're trying to use that form in another state, what I've found is don't be surprised if someone in that other state says, this is not our specific state form, so we're going to be less likely to use it. So it may get turned down being used. It's kind of odd. I see powers of attorney every year. They get turned down. Families come to me. Now, I'm a little bit like my friend who's a doctor, and he has the impression that everyone's sick because everyone he sees is sick, right? I tell him, no, David, most people are healthy. You see the sick people. Likewise, probably most powers of attorney are great and they work fine, but I see the ones that are sick. People come to me and say, hey, the bank won't take mom's power of attorney. What do we do? Now, in the extreme, I've actually had two families come to me and said, hey, the bank won't take mom or grandma's power of attorney because she signed it more than 60 days ago. What do we do? Like, holy smokes, 60 days? There's no such rule that requires it to be signed in less than 60 days. But we're seeing many institutions will have an arbitrary cutoff. The more common cutoff tends to be about the 3 year mark. We're seeing many
Yeah.
institutions, hey, if it's more than 3 years old, we're not going to take it. What's also interesting is oftentimes they'll have a form that accompanies the power of attorney. If you say to the bank, would you please accept and pre-authorize my power of attorney? And bank signs, they'll say, yeah, we'll do it. Just sign our form. If you read the form, it usually has all kinds of release language for the bank. So in case they do anything wrong, you can't hold them liable. And then at the bottom, it says, this authorization expires 3 years from the date you sign it. That's kind of the rub that we run into because now the bank's got cover for why they don't accept it 4 years down the road. Did anything change? No, they still should accept it. So we see powers of attorney that get turned down frequently. Now you're left with, now we're going to have to go to court. And I talked previously about a guardianship or conservatorship. You're probably thrown into that realm, or you get the option of suing the bank, whichever you choose. So not great solutions if the power of attorney is turned down. Proactively planning can work a way around that. There's some other tools that we can use, but that is a caution. You have to compare. So if you're going to spend time in two states, make sure that whatever you have is going to be applicable in multiple states. And one other thing to note is when a person passes away, wherever you pass away, where you're a resident of, the assets you're going to do your post-mortem administration. For instance, you'll be probated in that state. If you own assets in multiple states, you'll do a probate in the state that's your primary residence, but you'll do an ancillary administration in the other state. And oftentimes that's two different lawyers, two sets of timelines, two sets of rules. And with proper planning, you can minimize the effects of that. In fact, even eliminate that. But you have to be aware of it. So if you own property in multiple states, expect that your family is going to do probates in multiple states when you pass away.
Again, another event, a life event. You buy a piece of property in another state, it is time to review the documents and review them with someone like yourself.
Well, the other one that happens is, mom dies, she lived in Wisconsin and she left you the house, right? And you don't
Okay.
think about it, right? Or Uncle Fred died and now you have a property in Tennessee that you own a partial interest in. You don't think about those properties, but if you pass away, now you're going to do a probate here in Georgia, you're going to do a probate in Tennessee, you're going to do one in Wisconsin because you own properties there, even if it's only a minuscule amount. Well, some states they'll have a minimum threshold, but don't be surprised if you end up having to file paperwork in 3 different states if you've not done any proactive planning to
Hmm.
ward against that.
You've written about estate planning since the 90s. Which piece of traditional estate planning advice do you believe is now outdated or incomplete?
Oh, that's a great one. I hear sometimes from people They say, I talked with my CPA, and my CPA said I don't need to do an estate plan because I don't have a taxable estate. When I first started practicing a million years ago, the estate threshold was $600,000. So if you had more than $600,000, then there was some estate tax that you had to pay. Now, if you worked with an attorney, usually we could find ways around it and get you out of the tax, but you had to put some tools in place. Some of them tended to be fairly complicated the more you had. And the reason you wanted to avoid those is because the marginal tax rates frequently were 50% or higher for assets that you had above 600,000. Well, today you can't own a house in Georgia without exceeding the $600,000 mark. The nice thing is the rules have adjusted, and over your lifetime and my lifetime, those numbers have gone up, they've gone down, they've bounced back and forth. Currently, they're set at $15 million. Right? So most people go, hey, Mike, I don't have $15 million. What do I have to worry about it? Well, CPAs confuse estate tax planning with estate planning. Estate planning is how do you protect what you have for those that you want? It's not just how do I preserve taxes? And so sometimes CPAs get in their mind, oh, we don't need to do an estate plan because you don't have more than $15 million. And nothing could be further from the truth. If you care about what you have and you want to give it to the people that you want, you need to put an estate plan in place.
Yeah, great advice. Great advice. When you say clients should leave their wealth to whomever they want, whenever they want, and in any way they want, which of those decisions is usually the hardest for the families to make?
Oh, that's a great question. And different families have different answers on that. Generally, they can figure out who they want to leave their assets to. The harder issue is when and how. So, a particular beneficiary may be fully capable of receiving an inheritance, and it's not going to be a big problem for them. You know, they're financially responsible, they've got a job, solid marriage, doing great with the kids. It may make sense to just leave a distribution to them when you pass away, no strings attached. Increasingly, we're seeing families where there may be a child or beneficiary that's had some challenges. Maybe they can't hold a job. Maybe they got a lousy marriage. Maybe they've been divorced 3 times. Maybe they're incapable of making financial decisions. In that scenario, then you don't want to leave a lot of money outright to that particular beneficiary. One of the worst things you can do is give money too fast to a beneficiary. When I was in law school, I worked my way through school by working nights at a grocery store. And one of the girls that I worked with, she received an inheritance. Her grandparents passed away and they gave her $15,000. So she did what any 21-year-old would do. She immediately went out, bought a sports car. She bought a Mazda RX-7, if you remember what that car was. It's a
I
hot
do.
little car, right? Well, I ended up graduating, left that job. 10 years later, I happened to go back through town and I wanted to see, you know, my friends and see what happened at the grocery store. I should have checked the parking lot to see if the car was still there. It wasn't there. But what happened was she did not go to school. She ended up staying working at the grocery store. Now, there's nothing wrong with the job at a grocery store. It was honorable work and she's a great person. But I think grandparents would have intended that money to be used for something more than just a sports car that
Sure.
a few years down the road was no longer working. You know, it's going to be gone. So giving money too soon to a person can ruin them. By the same token, giving it to them too late as well. You know, if you wait till they're 75, life's already over. So if you give it to them when they're 75, what are they going to do? Nothing other than pass it on to their grandkids. So there's a balance here. And you want to do it in a fashion that's going to help the beneficiary. We have a particular client that's got a daughter who's got bipolar. She can't handle finances. And so we've created a trust for her. Mom died, we set the money in the trust. The trust went and bought a condo. Daughter can't pay the condo bills. She's incapable of doing it. So the trust pays the condo bills. They pay the utilities. They take care of that for her. They give daughter a little stipend each month so that she's able to buy her groceries and do whatever. In conversations with the mother, we said, well, what if daughter runs out? She said, well, then daughter's going to have to tough it until the next month. Now, if we had just given an annual sum to her and she runs out in February, then she's got 11 more months to be without it. But the
Yep.
mom thought every month, you know, she may run out halfway through the month. So she's going to have to figure it out for the next 2 weeks, right? And so that worked for her. I heard a phrase one time. I wish that I'd come up with the phrase, but I heard it. So I can't claim credit for it. I don't know who I heard it from, so I can't give proper attribution to it. But this is the phrase: there is nothing so unequal as treating unequals equally.
Huh.
right? As parents, we always want to be fair. That's the thing that our kids come back to us, right? Be fair. And somehow we've impressed on our minds fair means treating everyone exactly the same. The reality is they're not the same. You take the classic situation, you got three kids. You got the one kid who disassociated from the family, has been gone. They moved away across the country. They've changed their political, religious affiliation, and they have no contact with you for a few decades. All right, child number one. Child number two, they're great. They're here, and they come and see you once a quarter. And you got child number three, the child who lives down the street, and they see and talk to you two times a week, and they make sure you get your groceries. They're checking up to make sure you get to your doctor's office appointments, etc., on time, and you get to see the grandkids on a real regular basis, and they invite you over for dinner on a real regular basis, right? Three completely different scenarios.
Mm-hmm.
But somehow parents have ingrained in their mind, I need to give each one of them exactly the same thing. I like to give them permission that you don't have to do that. If you want to, you can, but it's also okay to be fair without being exactly equal. So, when, how much, that's a very personal decision. That's why you're sitting down with an attorney and thinking through this and talking about your life, as opposed to just going to the internet and trying to print off a document that has your name slipped into it. If you want an estate plan that works, it needs to be personal to your situation. We already mentioned you need to make sure that your assets properly coordinate with the plan. The helpers that you have, they need to be aware of what's going on. It's better if they're trained in advance. And then the last thing is, changes are going to happen in your estate plan. Do you have a formal way of addressing those changes? And if you've done those things, then you're going to have a great estate plan. If you don't, then it's probably time to take another look at it.
Mike, this has been great information. I really appreciate you joining me today.
Thanks. I appreciate being here.
Can you let our listeners and viewers know how to find you and how to reach you if they need to?
Sure. Our website is Bascom Law, BASCOMLAW.com. That's probably the simplest way to reach us. Or if they want to call us at our home office, 770-889-3911. We'll be happy to speak with them.
That's great. That's great. I hope this has been very informative for everyone. Thank you for joining and watching and listening. If it has been helpful, please make sure you share this with anyone that you think might need this information. Until next time, again, thanks for joining us. Take care.
You've been listening to Crashes, Claims, and Clarity with attorney Darrell Burrow, founder of Burrow and Associates and a trusted advocate for over 30 years. If today's episode helped bring clarity or hope after an accident, be sure to follow, subscribe, and leave a review. To connect with Darrell or learn more, visit legalatlanta.com. Join us next week for another honest, faith-centered conversation about recovery, rights, and moving forward after injury.